Good morning. It is 8:30 a.m. on the 5th of May. This is a special docket for notice of violation cases issued by the division to particular respondents. There are 12 on the docket today. We're going to start with number one. It's case number 25872. This is the Oil Conservation Division versus Oleum Energy. Entries of appearance, please.
Yes, Michael Hall on behalf of OCD. We have entered into a stipulated final order with Oleum. It's been executed by both parties, so we're asking that the hearing be vacated and the case dismissed based upon that.
Okay, and what are you going to file?
I have filed a motion to dismiss with an order. Sorry, I was working a little late last night, so it probably hit the queue after 5.
So let me ask you something then. So our standard procedure would be that the stipulated final order goes to the director after the respondent signs it
Correct.
for the director's signature. Then what happens to this final order?
Both those events have occurred. The director has executed that one.
Okay.
It is sent to Mr. Jackson, who assigns it a specific number for SFOs, as well as MOD-IE. And then the next step is to dismiss it or move to dismiss it to your attention with an order. And I guess procedurally, I'm sure you would like to assign it an R number, and in my opinion, that would be the mechanism to do that.
Okay. And are you going to include, you said MOD-E will have a copy of that stipulated final order?
And it is attached as an exhibit to the motion to dismiss.
Okay. And it's in the queue?
It should be, yeah, unless my finger hit something wrong. I sent it to Freya. It's actually Freya I sent it to last night. Yeah.
Oh, you sent it to Freya?
Yes.
Okay.
So I think I sent the SFO to MOD-IE once Albert had executed it, but I sent the motion to Freya.
Okay. Okay. All right.
So we can check on that, but I'm pretty sure it's in your queue.
Okay. MOD-IE, will you make a list of cases to check for, because if the director signed the stipulated final order, I'll sign the order dismissing the case once I get that motion and that attachment for the exhibit.
At 5:47,
Okay.
Mr. Hearing Examiner, at 5:47 yesterday is when I submitted that.
All right. I didn't hear anyone for the respondent on the line, so this case is dismissed and we're off the record in that case. Let's move on to Blue Ruby Operating, who is the respondent in case number 25928. Entries of appearance, please.
Michael Hall on behalf of OCD, ready to proceed.
And do we have anyone from Blue Ruby Operating? Mr. Hall, have you been in touch with anyone at Blue Ruby?
A long time ago, they asked for a continuance to this date. Have not heard from them since, although I do think, if my memory served me, they asked for a link to the hearing yesterday. They requested that from Freya, but nothing of substance regarding the case.
All right. I'm going to call again. Is there anyone representing Blue Ruby Operating? Not hearing anyone. Mr. Hall, go right ahead.
Thank you. Give me 1 second. I'm pulling that one up. But yes, OCD would offer, I believe it's going to be, and I'll confirm, exhibits 1, 2, and 3 attached to our pre-hearing statement.
Admitted without exception.
Okay, let me just give me, if you don't mind, 1 second to be sure. My computer's working, but it's not going fast. I just want to confirm that actually there's 4 exhibits. We also offer exhibit 4 attached to our pre-hearing statement.
Also admitted.
Thank you. Yes, generally this is a case involving 8 wells, all 8 of which are inactive. So we're seeking plugging authority, the ability to terminate their authorization to transport from all 8 wells, as well as a civil penalty in the amount of $3,600.
Okay. Your exhibits have been admitted and the case will be taken under advisement. So is this something you're drafting in order?
I can draft the order and I'll be as quick as I can on that.
The orders from the last docket, are you still working on?
I am,
You are
yeah, I'm
still-
sorry. This docket kind of required more stuff. So I should have that to you,
Okay,
certainly this week.
all right. So we'll have a proposed order from the Office of General Counsel. Okay, we're off the record in that case. Let's move on to Colthurst Management and Investment respondent in case number 25940. Entries of appearance, please.
Michael Hall, on behalf of OCD.
Good morning, Mr. Examiner. Jacob Everhart with Beatty Wozniak, New Mexico, appearing on behalf of Colthurst Management Investment, Inc.
Good morning, Mr. Everhart.
Good morning.
What's your client's position on this case?
Yes, we've had some promising developments over the last few weeks since our previous status conference. We've briefed Mr. Hall here yesterday, kind of laying out those developments. But in short, the 3 wells that are listed under the NOV have line of sight to either being RTP'd or being worked over to either bring back or P&A altogether. The deal hinges on the 3 wells in question are going to be kind of transferred to another operator, and that deal is papered up currently. That's expected to close mid-June. So the ask here is for another status conference planned for June 2026, after which we will have a lot of these issues remedied and a lot of these, I think, outstanding questions probably answered.
So, Mr. Everhart, I'm a little confused. What were the original charges?
I can bring up the NOV. There are 3 wells total, and they are the only 3 wells that are listed under this operator. One on the I guess that's Aaron number 2 well. It's a notice of intent to P&A. The other 2 were just inactive for longer than approved. So those wells that were inactive were going to be brought back online, along with a lot of remediation and reclamation work around the tank batteries that are going to be performed by the acquiring company, and also a P&A on the Aaron 9, or bring that back to production after they kind of evaluate it with some pressure support, some disposal prospectivity, I guess.
Okay, so how does that deal with the alleged charges? The fact that you're going to, I guess, in some way remedy some of the charges, and you're
Yes,
going
sir.
to be transferring the wells to another operator.
Yeah,
How does-
as a condition of kind of acquiring the wells, they're either going to be kind of brought back online, or they're going to have all the work that are outstanding under the NOV accomplished. And so these violations will be remedied. The goal for the acquiring operator is Waylander. They're going to start kind of developing the broader kind of development area after they work through these issues. But the whole thing was contingent on a BLM lease, and it was kind of in limbo. But we've had promising conversations with the state director in New Mexico, the BLM, verifying that the lease will not be canceled. And so now that the lease and the title check can transfer to the acquiring operator, they kind of green lights all the work to be done to kind of remedy all these outstanding violations.
Okay, Mr. Hall, your position?
Our position is we would like these wells to be brought into compliance. So that's positive. Our request would be to set this for hearing on the June 25th docket, with certainly we will be reasonable in our agreements to a continuance given positive developments continue. So that would be our request. We share their sentiment that these are positive developments. However, does not resolve the NOV yet. So we'd like to kind of keep this moving forward And I'll represent to yourself and Mr. Everhart, we will not unreasonably withhold agreement to a continuance given other positive developments. But we would ask for it be set for a final hearing for the 25th.
You heard Mr. Everhart on the fixes, but how does that address the underlying allegations?
Well, I understood him to say they're planning on developing the wells and make them producers. So if the wells are brought into production, then that wouldn't resolve the violations. They would still need to pay a civil penalty, but that would resolve the noncompliance going forward, but not in the past. So we want wells either plugged or producing when they've fallen into inactivity like these have.
So based on what Mr. Everhart said, if all of that comes to fruition, how does that affect the underlying violations?
It doesn't, other than we would have the ability to make, LCD would then be able to analyze this and make an agreement. I'm optimistic. There's not a large amount of civil penalties we're requesting in this. So I'm optimistic that we could come to a resolution on that. I believe Coolhurst will admit to their violations, and that would resolve the NOV for the past noncompliance. And then obviously we want to be sure they're complying going forward.
Okay, that makes some sense. Mr. Everhart, I'll set this for June 20. What did you say, Mr. Hall?
I believe it's June 25th this year. 8:30 is, if I'm not mistaken, that's our next special docket for inactive wells.
I was wondering, Madi, do you know?
Mr. Hearing Examiner, that's correct. It's June 25th.
All right, thank you. That's almost 2 months away, Mr. Everhard. At that point, I won't continue this case any longer. So if there is a
Understood.
continuance, I won't approve it. So please be prepared to go to hearing unless you want to work out something with Mr. Everhard where his client admits the allegations and all that's left is the fine. That's fine as well. But I won't continue it after June 25th.
Fair enough. We'll be ready to proceed, and
All
we'll we'll be available to speak to Mr. Everhart and Mr. Swazo, hopefully to resolve this matter.
Mr. Everhard, is there anything else?
No, sir. Thank you.
All right, thank you, sir. Thank you, Mr. Hall. We're off the record in this case. Let's move on to Oil Conservation Division versus Respondent FE-NM in case 26041.
Yes, OCD present and ready.
Do we have anyone from the respondent?
No, but that's not unexpected. We have the director has signed off and the operator has signed off on a stipulated final order. And so we have resolved the NOV in that manner. And so we're asking that the case be dismissed.
So we're going to be handling this in the same manner as we're going to handle case number 1.
Yes, sir.
Have you already filed the motion to dismiss it with the attachment?
Yes, sir.
You have. Okay, so we'll be getting it any minute now. Okay, we're off the record in that case. Let's move on to case number 5. This is Oil Conservation Division versus Finally Resources Respondent in case 26042.
OCD's present and ready. We're asking.
Hold on. Do we have anyone from the respondent? Mr. Hall, I have a question for you.
Sure.
Since we're waiting for someone to represent the respondent. In the future, if you do come to some sort of agreement that the case should be continued, I still want to hear from the respondent.
Fair enough. And I did. I agree with you. He asked, should he be there? I said, I can't give you legal advice, but I also can't speak for the hearing examiner. And so I encouraged him to be here. He asked for a link. So anyway,
So we don't hear anyone from respondent, Big Eddie. Finally Resources, is not here today. In the future, when you do speak to these respondents, please let them know that I expect them to be here.
sure.
It helps me make decisions when I can speak to their respondents, even if it is just, would you grant a continuance?
Understood. I will pass that along.
So you're asking for a continuance in this case?
We are, in fact, Finley Resources has signed an SFO.
Okay.
The director hasn't signed it. It's under review by him. And so that's kind of last minute, reaching our resolutions. So we're asking it be continued to the next docket
Okay.
so that, to give the director time to review that.
When was this case filed?
That's a good question. Let me pull it up.
Morning, Mr. Padilla. Good to see you.
No, my computer's going slow again. That's, oh no. Golly. My computer's not working again.
Mada E, can you tell when that case was filed? Finally, Resources, number 5 on the docket.
Give me 1 second, let me search.
Mr. Hall, I received a message from Ms. Chance, the hearing clerk. She had advised the representative for Blue Ruby that we were starting at 9 today. So
Whenever I figured you had gotten that same message,
I
but
just got it now.
I was gonna point that out just a second ago. I got the same message. So we don't object to reopening that and giving them the
Perfect.
chance to participate.
Perfect. I'm going to recall case number 2 at the end of our docket.
Okay. I might, with your permission, need to go upstairs. I'm having a hard time with the Global Protect.
Are you using the Wi-Fi?
I don't know. I'm trying to use
Okay, go on your laptop and select Wi-Fi and turn on Wi-Fi.
Okay.
And then log in under the user, mnerd user.
okay, I'm there and it's still doing this.
When you come downstairs, do you restart your computer or do you have it from upstairs?
I did not restart.
Why don't you
today.
restart your computer? I
Okay.
think that'll fix it. As long as the Wi-Fi is on, it'll connect.
Yeah, it says it's connected, so yeah.
It doesn't necessarily mean it's connected.
Okay.
I've been through that a million times.
All right.
Mada E, did you see when that case was filed?
Yes, Mr. Hearing Examiner, the notice of violation, I see it was the, February 19, 2026.
Okay, thank you. So, Mr. Hall, while your computer is
Yes, sir.
restarting, I'll grant the continuance to the June 25th docket, but that'll be the final setting on this case.
That works for us. I think it'll be resolved and dismissed by that.
Sounds
by
like
that
it will
time.
be. Okay, so we're in recess on Finally Resources, case number 5. Let me know when your computer is back up.
It's restarting now.
Yep.
I apologize. it's saying it's not connected. So I'm not.
So you're not getting any signal at all, or you're not getting a secure signal?
It says that I'm connected and secured, and yet I cannot, for instance, pull up, these files off the server.
Oh, so you're trying to get into the secure area with Global Protect?
So I'm trying to access.
Hold on one second. Let me ask IT.
Leave the VPN. Give you prompts now. Okay. This got connected, and I'm able to pull up my file.
You are now?
Yes.
Okay, fantastic.
I think I'm ready.
So I'm going to call the next case then.
Great.
All right, we're on case number 6. This is Oil Conservation Division versus respondent George Denton in case 26066.
Yes, OCD is present and ready. We have moved at Mr. Denton's request to continue this based upon, and Mr. Denton has shared with our engineering and myself some documents relating to plugging of the only well at issue. It's been a while since he's been in the game, and he's having a hard time submitting these properly. But I am satisfied that he's doing that and on the process of plugging the well, which is of course our desire. So I agreed to a continuance to give him some time. He's working, I believe, with Dean McClure to get those documents submitted properly.
Do we have a representative for him here today?
Not that I'm aware of. I have spoken to him on the phone. I think he has limited ability to maybe use the internet. I believe Mr. Denton's pretty old. He likes to, for instance, go into the Roswell office and talk to people instead of email. So that I hope I'm not, if Mr. Denton is available, I hope I'm not wrong on that, but that's my impression.
Okay. In the future, when you speak to respondents, please let them know that if their case is on the docket, I'd like to hear from them.
I sure will.
As well as you. So Mr. Denton, are you with us? Not hearing it, Mr. Denton. So you're asking for continuance to June 25th?
Yes, sir.
And was this case filed also in February?
This one would have been filed after that. I can give you an exact date. I say that. Let me confirm. I'll just tell you when we filed it. March 25th, it looks like, is when we filed that one.
Okay. So I'll grant the continuance to June 25th docket. And at that time, do you expect to go ahead with the hearing, or do you expect a stipulated final order to be executed?
I'm optimistic that we'll have a stipulated final order. I can't speak to his ability to get everything filed the right way, but I can, I think, speak to his intentions of doing so. So I'm optimistic we'll have a resolution.
And this is why this is why I want the respondent here so that he can speak to his own ability to file and let me know what issues he's having or what concerns he has.
I can certainly understand that.
All right. We're off the record in that case. Let's go on to case number 7. This is Oil Conservation Division versus G&G Oil and Gas. Respondent in case 26067. Issues of appearance, please.
Michael Hall on behalf of the Oil Conservation Division, ready to proceed.
Thank you.
Mr. Examiner Ernest L. Padilla for G&G Oil and Gas.
Good morning, Mr.
LLC.
Padilla.
Thank you.
What's your client's position?
On Friday, and I don't know whether we filed timely, we were unable to file. When I got this case, it was past the pre-hearing deadline.
Got it.
And so we didn't file a pre-hearing statement, and we're not really essentially prepared to proceed today. But I have talked to Mr. Hall. We have settled the case with the Commissioner of Public Lands to the tune of $600,000 to plug 5 of the wells that are in contention here. And by operation of law, it's our position that the land office is now on the hook to plug those 5 wells. The motion to dismiss that I filed on Friday, and Friday, we had at my office an internet outage, so I couldn't serve it. Caitlin Luck filed for me, and I'm not sure if she served Mr. Hall.
I did. I received Monday, I believe yesterday, I received something. I would just, while I'm answering that, there's no legal authority attached to this motion to dismiss or Mr. Padilla's, other than his objection to our affidavits. We're ready to proceed with live testimony. But there's no legal authority, nor could it be that a settlement with an entirely independent agency somehow deprives them of operatorship. OCD was not a party to any such settlement. And so we vehemently disagree with that position.
So, Mr. Padilla, I haven't seen this document. Did you file it into this case?
We did.
Oh, you did.
G&G, like, we just simply sent it to Freya.
Oh, you
and
emailed it.
She filed it.
She filed it.
She filed it.
Your client doesn't have an OGRID number?
They have an OGRID
Oh.
number, but under the permitting system, G&G did not authorize me to file directly into the case, so we sent it to Freya. And we also sent the entry of appearance
Okay.
together with a settlement agreement that we attached to that.
Let me find your filing. Hold on. Madi, are you logged into the imaging system?
I am.
You are, okay.
I can, let me clarify. Caitlin sent her the motion to dismiss on May 1st, Friday. And just for clarity, I received, after the deadline for pre-hearing statements, Mr. Padilla correctly pointed that out. I received his entry of appearance with the attached, purported settlement agreement on, April 29th, which was Wednesday.
All right. I have to use a roundabout system because this iPad does not have secure access, so I have to use a different system. So give me a minute here. 26067. All right, let's see what we got here. The last filing I have is from May 1st. This might be motion to dismiss. I have your motion here. Let's see what it says here. G&G moves to dismiss this NOV because G&G is no longer liable to the wells at issue pursuant to a settlement agreement with the state land office. G&G has reached agreement with the state land office in a district court case. Pursuant to the agreement, with the State Land Office, G&G no longer holds any interest in the wells at issue. Copy of the settlement agreement was filed with G&G's entry in this case on April 28th. Okay. For these reasons, a full dismissal of the NOV, and you are opposed, obviously, Mr. Hall. You just said vehemently. So, Mr. Padilla, let's flesh this out a little bit. So there was a district court case in which your client was it a civil case?
It was a civil case.
And who filed it? You or the State Land Office?
State Land Office filed the case, and the purpose of the case was to compel G&G to plug the wells that were on state oil and gas leases that had been terminated.
I see.
And
you reached an
yesterday-
agreement. And you reached an agreement with the State Land Office.
yes,
And your agreement, and you are asserting that the agreement with the State Land Office somehow nullifies the notice of violations from the Oil Conservation Division. What's the legal authority for that statement?
the legal authority simply the settlement agreement. I mean, that they following the settlement, Mr. Biernoff, counsel for the land commissioner, asked if we would file a C-103 for their contractor to plug the wells, and we said no. You have to now file the C-103 for permission to plug the wells. And nothing has come from that. I think yesterday we did get a final order of dismissal in that lawsuit. Our focus has been to settle this lawsuit because of contempt and issues about piercing the corporate veil that we were litigating.
I have a question. This settlement agreement, and Mr. Hall, I'll come back to you, so I haven't forgotten about you. But I'm looking at the settlement agreement and I see it signed by a Robert Garner. Is that your client?
That's my client, that he's the manager of G&G.
I don't see it signed by Miss Garcia Richard.
It was signed by her.
I see at the very bottom
Yep.
the page. I don't know why it goes from paragraph 8 on page 2 to paragraph 6 on page 2. Oh, I see. So you have signatures and
2 pages of
sort of
signatures.
disjointed here.
Yes.
Okay, all right. All right, give me a minute here. Let me.
Yes, Mr. Hearing Examiner, since we're speaking about apparently what Mr. Biernoff has told people, can I quote him from an email yesterday?
Sure.
Certainly
Who's the
we,
email to? Who's the email
me.
to you? What's the subject?
regarding this case.
This case, okay.
Certainly, we do not purport to determine who is an operator of record for OCD purposes. And he doesn't think that settlement binds OCD in any way. Of course, that is contract law. We weren't a party to the settlement. But since he's saying what Mr. Biernoff told him, and I'm happy to provide that into evidence if need be. Thank you.
So, Mr. Padilla, you heard what Mr. Hall just said. What do you have to say about that?
Well, obviously, the OCD is going to look at G&G as being the operator. There's no C-145 to change the operator from G&G to the land office. But the primary responsibility now rests with the land office to plug those wells. I mean, we ponied up quite a bit of money to do that. And the focus that we had in the proceeding, or in this case anyway, I wasn't aware that my clients had received a notice of violation until very recently. And by that time, it was very late for me to file anything, pre-hearing statement. But we do feel that the responsibility now rests with the land office to plug those wells. Now, whether or not it will cost more than the settlement amount is not up to us to determine.
So I guess what the first thing I'm trying to find out is, and I'm looking at the NOV here, or the pre-hearing statement. I'm not looking at the NOV. Mr. Hall, would I see what the allegations? Okay, I think,
If you go to the NOV itself, which I should be exhibit 3 to that,
oh, it is?
it should be. Normally, I don't have, I'm looking at the settlement agreement right now, but I'll pull that up.
Exhibit 3 is blank in this case.
Okay, let me pull up the NOV.
That's, I can get to the NOV, but I was looking in the pre-hearing statement for the NOV, and it starts on, it says exhibit 3 on page 11 of 14, but there's nothing there. And then it goes to exhibit 4, which is affidavit of Madi Corral.
Oh, well, my apologies, I probably didn't get.
That's fine. I
attached
can
properly.
find, I can find.
But
it.
it's instead of 5 wells, it's 6 total wells operated by G&G, all 6 of which have been continuously inactive since at least October of 2018.
So Mr. Padilla, the allegations here, and I'm looking at the notice of violation, that was dated, let me see when it was sent to or signed by the director. I'm looking for a date that it was signed by the director. I don't see one. And I don't see, there isn't like a filing date on this document either.
Let me look in my email. I can tell you when it was.
Okay, it says here, on or about March 26th, the OCD issued an original NOV to G&G Oil and Gas with their OGRIT number.
That sounds right. And that would have been in the same batch as the finally we were just discussing.
So Mr. Padilla, your client, in the notice of violation, is alleged to is the registered operator of 6 wells. The 6 wells identified in Exhibit A have been continuously inactive since October of 2018 and therefore out of compliance with one of our rules, and are not already subject to an agreed compliance or final order. And then I think there is a sanction here, $2,700. So Mr. Padilla, with those very basic facts, how does the State Land Office agreement in your district court case cure the fact that these wells were inactive for approximately 7 or almost 8 years?
I'd have to concede that the wells were inactive, but my understanding is that the OCD originally notified G&G about 6 wells. We can only find 5 wells.
Okay.
And those are the 5 wells that were part of the lawsuit.
Okay.
So I don't know where the 6th well is. I tried to find it yesterday in preparation for this hearing today, and I can't find the 6th well.
There was, to help you, and I have it pulled up here, happy to let you look at this. The inactive well list, at the time, Mr. Jackson ran it, there's 6 wells, all oil wells. So anyway.
No, I get the
Okay.
6 wells. I just couldn't find the well that was not included in the lawsuit.
Oh, I understand. Okay. That's probably, it looks like there's one federal lease. And so that probably explains it since you were in litigation with the State Land Office.
If it's a federal lease, then the OCD doesn't have jurisdiction over that well.
If the parties could not go back and forth between each other, it's not proper etiquette for the forum. So let's stop doing that. Mr. Padilla, the OCD is ready to proceed with its evidence. You have a motion to dismiss. I understand that you assert that the settlement between the state land office and your client somehow invalidates most or all of this NOV. I'm not understanding the legal argument behind that. And I need to understand the legal argument based on, first of all, it's opposed. It's an opposed motion. Second of all, I don't see any law or case law or anything here to support that rather novel assertion. I can do a little bit more research here. So give me 1 minute here.
Mr. Examiner, I just simply did.
Hold on a second. I just need a few minutes. Give me a few minutes here and then I can hear whatever else you want to tell me. I'm happy to hear, but I want to do a little bit of research here. Mr. Hall, what is the NMAC citation for inactive wells?
It is. There's kind of a couple, but it's a 1915-25-8 As well-
25.8.
and as well as 1915-5-9.
Okay, you went a little fast for me. Will you say it again?
Sure. Second one,
Yes,
1915-5-9.
5.9.
Yes, sir.
Okay.
I think it was a week ago Friday. And we were, at the time that we entered an appearance, we were waiting for, there'd been a contempt citation for $60,000 by the district court against Mr. Gardner personally. Essentially, the court pierced the corporate veil. We disagreed that the contempt citation pierced the corporate veil, but nonetheless, we were focusing on settling the case. And I mean, there's very little that we could argue in terms of whether the wells were inactive or not. But yes, it was entered. I think the last signature from the commissioner was on Friday of a week ago, Friday.
April 16th is what it shows in the document I have.
Citing. It's just what I'm thinking about as I'm trying to understand your position in abstract. Give me any legal authority to find.
And Mr. Examiner, I just didn't have time to, I would have researched an intervening event as by operation of law, the line commissioner became the
the framework. So, state that. Um, I think that under that framework, so versus state framework, there's a key distinguishing between two agencies. One is proprietary, state land office is proprietary, you share the capacity. As landlord trustee for the state trust lands, and the OCD is the regulatory capacity of the state police power to prevent waste, protect the environment. And because the OCD was not party to the district court case, it has a separate statutory mandate. I don't think it's considered in privity with the state land office for the purpose of settling regulatory violations. And I think there's another court case, Richard versus Marathon Petroleum Corp. And you know that case, it just came out last year. New Mexico Court of Appeals emphasized that for settlements by the state land office, not automatically absolve an operator of statutory or regulatory liabilities. So, I mean, that case is pretty on point, Richard versus Marathon Petroleum Corp. 2025. The cause of action is not identical either. Here in the state land office civil settlement, we're talking about lease contract trust mandate. In the OCD action, NOV, it's enforcement actions. The goal is different, the remedy is different. I don't see that. So I'm not that you're arguing it, I'm just not seeing that at all. The OCD wasn't even aware of this issue. Does the settlement language explicitly mention regulatory or OCD claims? See that, Senator?
Mr. Examiner, I agree with what you're saying. I mean, I don't have any dispute with the cases that you're citing. I just simply think that there's an intervening factor here that, as to the 5 wells, that the obligation of plugging those wells is shifted to the land commissioner now by operation of law.
So, based on what I've heard so far, deny the motion to dismiss. Because we need to go forward with this case. I know that you didn't have the opportunity, for whatever reason, to file a hearing statement. But had you had that opportunity, do you have witnesses available to testify?
Up today, the person that I would call today, and he's not available today, is Pat McMahon, a lawyer in Lovington, who essentially negotiated the final phase of the settlement. No, I think, Mr. Examiner, I think the wells are inactive. They have been inactive. I'm not going to dispute that. The thing about it is that an compliance order is going to require G&G to plug the wells. We're saying that it no longer is obligated to, but I don't have an argument against the two government agencies, one proprietary and the other a regulatory agency. And I think the OCD definitely is going to look at who the operator on record is. So I don't have an argument against that.
Why you're closed or not, I haven't seen closed order. I think that you've got plenty of time to file something with the Office of General Counsel, Mr. Hall specifically, and with me, to show that that's for some reason not appropriate in light of the settlement agreement that you brought up. And then we'll have to be fully funded. And if you don't like that, you can always appeal it to the commission.
Sure, I agree, and I figured this is a totally different case that normally comes before the OCD for hearing. It's got implications from the litigation that are perhaps I would like more time to file before we proceed to final order. I would almost say that the wells have been inactive, and under the rules of the OCD, yeah, they're inactive wells. Whether or not the compliance order that may be issued here is appropriate would be a different deal. That would be go to appeal. No, it doesn't. This was the earlier versions of that settlement agreement did identify the 5 wells, and so does the complaint in the lawsuit. That's pretty lengthy. But the final version of that settlement agreement did not name the 5 wells, did not list the 5 wells, nor did it. But we felt compelled we needed to settle the case, and my client was able to come up with enough money to satisfy a settlement.
on the settlement. But it sounds to me like this doesn't address the plug of the developer.
No, the final settlement agreement did not, but the settlement contemplated that the land office would hire a contractor. And that's where the issue of whether or not G&G should sign a C-103, and I advised against that simply because by operation of law, G&G no longer is the operator of the well. I mean that the lawsuit required or sought to compel G&G to drill the wells. I mean, plug and abandon the wells and do the surface remediation, which is expensive. G&G was very reluctant to do that and wanted to settle the case simply because I have a client, Mr. Gardner, who was pretty sick guy. And he asked us to try and settle the case with money. And that's what we did.
I have not, other than, no, I haven't. I have spoken to Mr. Biernoff. He refutes their statements here. The settlement agreement itself refutes these statements. It says nothing about plugging. It says environmental damage and solving and resolving contempt. Here's the most important part of that. Besides OCD not being a party to this, they don't admit liability. They specifically disclaim liability. So they're claiming that this somehow absolves them of plugging liability, yet they don't admit liability. So this is absolutely the proper forum to determine that and to force them to plug these wells should that be your decision.
This was filed in March. And Mr. When did you get this?
I got it probably Thursday of last week. No, I pulled it down. Actually, by that time, I had the pre-hearing statement that Mr. Hall filed. And I didn't, because Exhibit 3 was not attached, I couldn't see what the NOV was about. I did eventually get a hold of that. But it wasn't in the pre-hearing statement, so that's. Yeah, I of course. Well, yes, we object. I've already argued that, that, and what is being sought here is that G&G is going to be through a compliance order required to pony up money to plug those wells again. I mean, it's a double jeopardy kind of thing, is that and I'm just it's not a criminal thing, Mr. Examiner, but what a compliance order is going to require G&G to if it requires to plug those wells, we're going to be litigating forever on this thing.
Well, that's the process, Mr. Padilla. You should be used to the process.
Oh, I am.
You've been around quite some time and you know how to use the imaging system and to find the NOV once you're in the imaging system. I'm going to allow the OCD to proceed with its case. I will give you an opportunity to call a witness. I realize it's not fair to Mr. Hall because you haven't filed a pre-hearing statement. I'm not even sure that your witness's testimony is relevant in this case, but I'm willing to bend over backwards so that you can, admit your evidence. You have an opportunity to cross-examine the state's witnesses today, so you're more than willing and capable to do that. So, Mr. Hall, which exhibits do you seek to admit at this time?
I believe Mr. Padilla has objected to our exhibits, so Mr. Jackson is here available to testify.
So
Now,
which exhibits?
But I also understood him to be stipulating that these wells are inactive. And so if that is a stipulation, I think that resolves the case. So
It resolves part of the case. Is that the only allegation?
the only allegation is inactive wells.
Six inactive wells. I think Mr. Padilla was willing to admit 5 of them were inactive.
Well, sure. I think he now understands that there were 5 state wells and 1 federal. So
I can't put words.
I can't
into
speak for him either, but I believe that's accurate. However,
So which exhibits are you seeking to admit into evidence? Let's try this again.
none. I call Rob Jackson
Okay.
to testify.
Okay, Mr. Jackson? Mr. Jackson, would you turn on your microphone, please? Would you raise your right hand, please? Swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you. Would you spell your name for the record?
ROBJACKSON,
And what is your position at the OCD?
Senior Manager of Business Operations.
Okay, Mr. Hall? Go ahead.
Thank you. Mr. Jackson, are you familiar with the operator G&G?
I am.
Did you help draft an NOV against G&G Oil and Gas LLC?
I did.
Okay. Would now offer the NOV in this case.
Well, the NOV is a document of administrative record, so
You can take notice of that.
it's already
Okay.
in the record. What we're
Right.
trying to admit at this point is the exhibits, the specific exhibits. Which exhibit does Mr. Jackson responsible for?
If the NOV is before you, we will just be providing testimony in
Okay.
that case.
So did you want to?
Yes, I
Okay,
will
go right
proceed
ahead.
if it pleases you.
Yes, go ahead.
Okay. Mr. Jackson, do you have a typical procedure for particularly with inactive wells for determining whether an operator is compliant or not?
Do I have a procedure for that?
Yes, sir.
Yes. It's basically running the inactive well report, financial obligations too.
And in this case, did you do that?
Yes.
Did the results show as of December of 2025 that this operator G&G had 6 inactive wells?
Correct.
And is the operator of 6 wells?
Yes.
So in other words, every single well they have has been inactive.
Yes.
Since 2000, do you recall the date? It's okay if you don't. Do you recall the date that they've been inactive since?
I don't recall.
Okay,
I'd have to see the report again.
sure.
You want to give the witness something to refresh his memory with?
Yeah, let me,
Just show Mr. Padilla first before you give it to him.
sure, it's just the NOV. Do you have that, Mr. Padilla? I'll pass it. Let's see, let me see if I can share my screen here. Actually, I'm not logged in. Just gonna go on. Mr. Jackson, just showing you here for the record, the NOV. And what's the date that these wells have been inactive since at least?
October 2018, it says there.
Thank you. And so, 1915-25-8 MAC requires operators to plug and abandon or produce wells after a certain time period. Is that right?
Yes,
Additionally, 1915-5-9 sets the amount of inactive wells that an operator is allowed to have under the rules, correct?
correct.
In this case, was this operator non-compliant?
Yes,
Okay. In fact, all of it's 100%.
100%.
Of the wells is never allowable under the rules, is it?
No,
Okay. Did you also have an opportunity to tabulate a civil penalty in this matter?
I did.
Do you recall what that amount is?
Not for this operator.
Okay.
What are you showing him, Mr. Hall?
I'm showing him the NOV again. And what is the amount you determined?
It was $2,700.
And is that generally on these, is the amount $450 per inactive well that you assess in that calculation?
Correct.
And so 450 times 6, 2,700,
Yes.
right?
Yes.
Okay. Now, OCD may impose sanctions of civil penalty, termination of a permit or authorization, the ability to transport. We can force plugging and abandoning of inactive wells. That's all what we're able to do when an operator is this non-compliant, correct?
That is correct.
As well as forfeiting financial assurance.
Correct, to recoup cost.
Okay. And so, so in this case, operator has 6 wells, all of them inactive. And that's what your research determined, utilizing OCD's permitting system, correct?
Yes.
I'll pass the witness.
May I speak to something that was said earlier about the federal well?
It's okay with me, sure.
Well, hold on, Mr. Jackson, one moment.
Sure.
Before you do that, Mr. Hall, in your NOV on page 8, you have an inactive well list.
Yes.
Okay. Mr. Jackson, did you create that inactive well list?
The report I sure did.
I thought you did. For the record, I want to get this entered into evidence.
I would offer Exhibit A to the NOV, that being the inactive well list as of December 30th, 2025.
Would you show Mr. Padilla
Sure.
it before we deal with it? Is there any objection, Mr. Padilla?
Objection. Objection. Federal.
Is your microphone on, Mr. Padilla? Would you say that again?
I have an objection I don't have an objection to 5 wells that are not, that on state oil and gas leases or state land now. But I do have an objection with respect to the federal well.
Okay, so Mr. Hall, does this witness have a copy of that list?
No, but I'm happy to show it to him.
Would you show him the list?
Sure.
And would you ask this witness questions to establish a foundation for that list? And then Mr. Jackson, I'd like you to read those API numbers and those well descriptions into the record.
Okay. Mr. Jackson, you compiled this list in December of 2025, correct?
Correct.
And that's not something you do, like you go search out the wells. This is the inactive well list maintained by OCD, correct?
Correct. It's automated report I can run.
Okay. That includes federal wells, doesn't it?
It includes all wells within the borders of New Mexico, be it tribal, federal, state, or private.
And so a plugging order on a federal well is something we can absolutely get, but we would perhaps coordinate with BLM on whether we or not we actually did plug it. Was that the procedure?
Correct. We coordinate with BLM when we're plugging federal wells and tribal when we're plugging on tribal land.
But when an operator is extremely non-compliant like this, it's NOCD's prerogative and in fact appropriate as a regulator to get a plugging order for all wells, including federal wells.
Correct.
Again, offer Exhibit A to the NOV, the inactive wells.
I just have a couple of questions for Mr. Jackson. Mr. Jackson, how do you know that that list there is accurate?
Per our IT department's construction of this report that I can run. And then I can go into individual wells and look at through the IT OCD permitting website and look up the statuses.
So was it Exhibit A, you said?
It's Exhibit A to the NOV, yes, sir.
So Mr. Jackson, Exhibit A, is that a accurate copy of the report?
Correct.
It is. And you ran that report yourself?
Yes.
Okay. And would you, so Mr. Padilla, based on those questions, do you have any voir dire for this witness?
Yes, I have questions. Sorry, I just had a senior moment. Please state your name again.
Rob Jackson.
Rob Jackson. I'm sorry. Mr. Jackson, does the OCD have jurisdiction over federal wells, over the operation of federal wells?
Mr. Padilla, that's not a proper voir dire question. I'm trying to decide whether to admit this document into evidence. I'm asking you to voir dire. I'm asking if you have any objection to the foundation, not to the legal ramifications.
No, I don't have an objection to the foundation.
That's what I was trying to get to.
Okay.
And I'll let you cross-examine this witness in just a moment. So Mr. Jackson, I am admitting Exhibit A of the NOV into evidence as the well list. Would you read the wells, the 6 wells and their descriptions into the record?
By descriptions you want.
I guess the API, isn't that the best description? I don't know. It's not my business. So
The API. yes,
Identify the 6
identifier.
wells.
Okay, first well is 30-025-22264. It is a state well oil. Second well is 30-025-28389. It is a federal well oil. Well 3 is 30-025-22666, state well oil. Number 4 is 30-025-22886, state well oil. The 5th one is 30-025-01122, state well oil. And the 6th one is 30-025-29-29417, state well oil.
All right, thank you. Mr. Padilla, your cross-examination?
Mr. Jackson, do you have a field report on this wells?
Do I have what?
Do you have a field report on this wells?
Field report? No, we have what the operator reports to us.
Okay, but your assessment of inactive wells is simply from a website, correct?
It's from reports submitted by the operator to our website that I run a report off of, correct?
Did you talk to anyone in Hobbs' office or the Artesia office, wherever these wells are located?
No.
Do you know what the condition of the wells are on the surface and subsurface?
I do not. That would be our engineering bureau.
Are you alleging that there's environmental pollution of any sort with regard to this compliance hearing?
No, not at all.
When you say, as I understand your testimony, that you have jurisdiction over federal wells, that you can issue a plug-in order on a federal well, is that fair to say?
I just want to I'm okay with that question, but a line of questioning that calls for legal conclusions about OCD jurisdiction, I would like a running objection to that line. That particular question, I think Mr. Jackson can answer.
Mr. Padilla, I'm going to caution you. So there's no objection to the question itself, but I'm going to caution you not to go too far down this rabbit hole with legal opinions. I'm sure you could frame it differently if you wanted to.
I'm sure I can frame it differently, but do you typically, does the OCD typically regulate federal wells?
Yes, the status of the wells, correct. In fact, it's to my understanding that BLM uses our data to regulate the wells from their standpoint.
So your answer just told me that the feds, the BLM, the Bureau of Land Management, actually regulates the federal wells.
We coordinate with the federal. They oversee it. We have to adhere to them if they override us, but we coordinate with them on plugging, and they use our data and we use our data to submit the plugging orders.
Do you know whether the the Bureau of Land Management would order a well to be plugged?
Objection. This is outside of the scope of the pre-hearing statement and the scope of designated testimony for Mr. Jackson. And so we have not designated him to testify about federal jurisdiction and plugging matters.
Mr. Padilla, your response?
Mr. Examiner, I'm just simply trying to figure out who regulates federal wells. I mean, whether it's the Bureau of Land Management or whether it's the OCD, and I'm very cautious now based on your admonition that I shouldn't ask about legal jurisdictional questions. And I'm not trying to do that. I'm just trying to figure out who has responsibility for federal oil and gas wells.
But Mr. Padilla, the scope of Mr. Jackson's testimony as an administrative compliance officer, basically, if that term is incorrect, Mr. Hall, I apologize.
I agree with that term.
Okay, fine. That is confined to what he does. What you're asking is outside that scope. So the objection was outside the scope of his direct testimony. So I'm going to sustain that. You can keep asking questions, but you have to stick within the scope of his direct testimony.
Okay.
Michael?
So, Mr. Jackson, so I understand your testimony. You simply took what is covered by your website in terms of production C-115 reports that the operator filed. Is that fair?
That's fair.
And you had no outside input for determining what the condition of the wells were?
No. Okay.
Objection. He has not testified about the condition of the wells, nor is that within the scope of this hearing. It's has to do with inactivity, not the condition of the wells.
I don't, Mr. Hall, I don't believe the question Mr. Padilla asked goes to the condition of the wells. I thought the question he asked was, you're not relying on anything outside of the operator's submissions into the database. And I thought he said no.
I might have misheard. I understood that part to be correct and then say to determine the condition of the wells. If I misheard, I apologize and I withdraw the objection.
Mr. Padilla, did you ask about the condition of the wells?
No, I didn't. I
Okay.
just simply asked who determines the BLM or the OCD.
Keep going, Mr. Padilla.
I know that you're not a petroleum engineer and you've been at this job based on your resume, for about 4 years, and also based on your affidavit, you simply, as I understand your affidavit, you simply took your information from the OCD website on whether or not the wells were producing oil and gas, correct?
Correct. It's basically an honor system that the operators report their production. And if they don't report their production, that's what I have.
Did you have any communications at all with anyone at the state land office?
No.
Do you know whether anyone from the OCD was in communication with the state land office regarding the 6 wells that are at issue here today?
I do not know of any communications there.
Mr. Jackson, if an order is issued by the division, well, let me ask it this way. Is it likely that an order issued by the division will require G&G to plug and abandon these wells?
I'm sorry, what was the question again?
Is it likely that a division order will require a G&G to plug and abandon these wells?
Understood. It's likely that they'll be required to return them to production or plug them.
Okay. Mr. Examiner, I believe that's all I have.
Thank you. Any redirect?
No.
Mr. Jackson, you're excused. Thank you. Okay, so Mr. Hall, let's review the evidence that we have admitted into the record so far. Why don't you tell me from your perspective what it is?
My perspective is there are 6 inactive wells. That document from OCD's records is in evidence. Mr. Jackson testified as to a civil penalty of $2,700, as well as the rules that are required of operators with regard to keeping wells active, and the remedies available to OCD. So I think all those are in evidence.
Okay, so is there any other evidence you feel you want admitted into the record at this time?
No, I think that hits the 4 corners of the NOV, which is our intent.
Okay, Mr. Padilla, so does the state rest its case?
Yes.
Mr.
Well,
Padilla?
with one caveat, I understood you to say earlier that you might allow them to bring evidence at a later date. So we don't rest if evidence is going to remain open.
I'm just asking you if you rest your case in chief.
Yes.
Okay, perfect. Thank you. Mr. Padilla, do you have a case in chief?
No, I don't.
Do you anticipate having a case in chief?
Yes.
Okay, when?
Whenever you set
Okay.
hearing.
Mata E, when is the next docket we have? And I don't mean NOV docket because I'm not going to wait that long. When is the next docket we have?
Okay, give me 1 second, let me check.
I think, and let me do a little thinking myself. We have something on the 7th. We have a hearing by affidavit docket on the 7th. Mr. Padilla, how long do you think your evidence will take?
I think I'll only have one witness, and that would be Mr. McMahon.
Okay.
That would testify concerning the scope of the settlement agreement.
Okay.
May I just,
Yes.
for purposes of preserving our ability, we object to that as
Right.
not being timely under the rules. They
course.
did not submit a pre-hearing statement. Understood you to say you're going to allow it anyway. That's fine. Just want to make sure our objection's preserved.
By all means. I'm giving Mr. Padilla every bit of leeway I can think of for him to present a full and fair case for his client. Whether it's relevant or not, I don't know. And that'll be up to you to object to. If it's not relevant, you'll object to it. So this may be a very short a continuation of the hearing. Mr. Padilla, we have May 7th is the next time that we have on the docket. We can put your case at the end of the hearing by affidavit docket, which means it probably wouldn't be heard until about noon or 1 o'clock or so. Your witness can appear virtually. I'll have to see him, but he's an attorney, so I'm sure he's able to do that. How does that sound to you?
Sounds better than I am today. For sure.
Exactly. Okay. So Mr. Mari, would you please continue this case to the end of the hearing by affidavit docket on the 7th, which is this Thursday? Mr. Padilla, it's this Thursday. You should be here, but your witness does not need to be here.
Okay.
All right. Okay. And Mr. Hall, I took it for granted that you would be here.
Well, while you were running those traps, I checked my calendar and I'm, could you give me a little clarity on what
Sure.
time?
I'm thinking there's about 40 cases on the docket.
Okay.
They tend to, we start, I think I don't remember, is it 8:30 Mari for the hearing by affidavit docket? I've now forgotten.
Okay, give me a second just
Sure.
to check,
Sorry, I'm throwing questions at you.
don't worry.
It's usually on what Freya sends out in her notice to the regulated public. Mr. Padilla, you might have received that email as well.
I probably did too.
And Mr. Hall, I bet you have it too. It was sent out
I see it's 9 a.m.
9 a.m. Perfect. Thank you.
So generally kind of after lunch, is that when?
With 40 cases, it could be right before lunch. It could be after lunch. We don't always take a lunch if we're thinking that, well, one more case and then we're done for the day. We'll just do it then and we won't take a lunch at noon.
I can be available. My request,
Yeah.
which of course you can deny, is that you and Mr. Padilla just give me a heads up when we're ready to go, and that way I don't have to sit through 40 cases. I don't think I'm actually representing OCD in those particular
You're
cases. So,
So what we'll do is, I'll ask Ms. Chance, I'll send Ms. Chance an email and copy you and Mr. Padilla, asking her to give you about a half-hour notice
perfect.
before our regular docket on Thursday is over. 11:30, maybe noon, something like that.
I'll be around. I
Perfect.
appreciate that courtesy of giving
Of
the
course.
heads up.
By all means. So Mr. Padilla, please let your witness know that we'll expect him to participate. I want to be able to see him to swear him in. I'm not comfortable swearing people in if I can't see them.
I understand that. Also, Mr.
Yes.
Examiner, I do want to see his availability in May 7th.
Of course. Of course. If it's something extraordinary, you can file a motion with an affidavit explaining why the 7th won't work for him. And then we'll find something else. Maybe it'll be the 13th. We could start on the 13th. We have another case that day, but we could start this case maybe at 12 or 12:30 that day. So if you want to offer that to your witness as well, if he can't attend late morning on Thursday.
Okay.
But those are our two options as we speak. And Mr. Hall, are you available at around noonish on the 13th if the 7th doesn't work? By all means.
Sorry. So maybe one would be better. There's some.
I can't do one. We have a hearing at 1 up in the conference room. This would be virtual. You can.
There's summations in the OCC
Yes,
web
there are.
rulemaking that morning is the only hesitation I have.
And
I don't know how long that's going to take. And so.
From my understanding, they're going to take a lunch at 12 o'clock for an hour.
Okay.
All right.
That is my only conflict
I
that day.
understand. Okay, very good. Which case are you involved with, Mr. Hall, on the docket?
The rulemaking for the inactive well rulemaking, OCC.
Is that the Welk rulemaking?
Yes.
That will start at 1 o'clock.
Oh,
I
okay.
can tell you now, I know when that will start.
Oh, okay. I had 9 a.m. So perfect.
They're gonna do other cases. So
Gotcha.
that the afternoon will be Welk, WELC.
And I think Mr. Tremaine will be available
Oh, okay.
too. So I can make it work.
Sounds good. All right, so Mr. Padilla, we're gonna wait to hear from you, but if we don't hear from you, we're gonna expect that you'll be here Thursday around 11 o'clock and your witness will be available starting at 11 o'clock. I don't know exactly what time we'll call the case. It'll be at the end of our docket.
Okay. I had a question. I'm just not sure. Oh, on the 13th, would that hearing be virtual?
I'm sorry, what now?
If the hearing is on Thursday, would that be, on the 13th, would that be a virtual hearing?
Yes, on the 13th, we're gonna be in the conference room upstairs. I won't expect you or Mr. Hall to attend in person. We can do that all virtual.
Okay,
On the
and
13th.
then on the 7th, though, we would meet here.
You and Mr. Hall would be here in this room because that's where I'll be. I'll be hearing by affidavits that day, but your witness can be virtual.
Right.
Okay?
Got it.
All right, we're in recess on that case. Let's call our next case, and that would be number 8 on the docket. This is 26068, Oil Conservation Division versus Respondent Giant Operating.
OCD's present and ready. Let me just get that one pulled up, Mr. Hearing Examiner.
Okay. Do we have anyone from Giant Operating? Any representative? Mr. Hall, once you get the case pulled up, will you tell me if you've been communicating with anyone at Giant?
I don't think I have in this particular operator.
Okay.
It will be in my pre-hearing statement. If so, there's a lot of these, as you're aware. Oh, wait. Yes, there actually has been. Sorry. There's an attorney that was the listed contact. She informed OCD that the operator was dissolved in a federal receivership. It's Miss Cook. She's an attorney in Dallas, is my understanding. That was via email. That's the only communication I received. That was shortly after, I think, filing the NOV and serving her with
Okay.
that.
Why don't you
And
present
have,
your case?
sir?
Why don't you present your case?
Sure. OCD would offer exhibits 1, 2, 3, and 4 attached to our pre-hearing statement.
Admitted without exception.
Okay.
And what is the allegations in this case?
The allegation is that this operator has 4 wells, all 4 of which are inactive. We seek authority to plug, as well as a civil penalty of $1,800, as well as termination of their ability to transport. All the relief requested in the NOV.
Okay. And what is the civil penalty?
$1,800.
If you said that, I didn't hear you. Okay, sounds good. Are you going to draft the order?
Yes.
Okay, very good. So we're off the record in this case. Let's move on to case number 9 on our docket. Oil Conservation Division versus Golden Oil Holding, case 26069.
Yes, this is another one we filed yesterday evening, a motion to dismiss. The basis for that one's slightly different. All of these wells are tribal. I have spoken to a representative of the operator, and there's been no request for OCD to do anything, and it's our policy that only when a tribe requests our assistance on a matter that we pursue an NOV. We discovered that after the filing of the NOV, so that's the basis of the dismissal.
Okay, so you're filing a motion and a proposed order with the hearing bureau or with the division?
The division. I submitted it to Freya yesterday.
So that'll go to the director then.
Well, it's for you to sign off
Ah.
on is how I did it, but whatever pleases you on that.
That's what I meant when I said, are you filing it with the hearing bureau or with the division? Meaning, do you
Oh,
want me to sign the order
pardon.
dismissing the case or the director?
I've submitted it to you. I
Fine.
don't have an objection
Okay.
to doing it a different way.
No,
but
it's
I
perfectly-
think that would work.
Perfectly valid to send it to me. Okay, so we're off the record in that case. Let's move on to case number 10 on the docket. This is Oil Conservation Division versus Respondent High Plains Petroleum, case number 26070.
OCD's present and ready to proceed.
Okay, do we have anyone from High Plains Petroleum? Mr. Hall, the usual questions about.
Sure.
Who have you been in contact with?
Let me pull this one up. I don't think anyone other than the state land office on this one, actually, they received, if I'm not mistaken, a judgment against them. But in a bunch, it's important for OCD to still get plugging authority, just for the way our procedures work. But no one from this actual operator has spoken to me. And it was as set out in Miss Corral's affidavit, they were served according to the information provided to OCD. So we would offer exhibits 1, 2, 3, and 4 attached to our pre-hearing statement.
Admitted without exception. And what are you seeking here?
In this particular case, there's only one well that's operated by this operator. That well is inactive, and so we're seeking plugging authority to terminate their authorization to transport. All relief set out in the NOV, as well as a $450 civil penalty.
Thank you. Are you drafting the order?
Yes.
You are, okay. All right, we're off the record in the High Plains case number 10. Let's go on to case number 11. This is Oil Conservation Division versus Respondent H.L. Brown Operating, case number 26071. Entries of appearance, please.
Yes, OCD is present and ready and would like to announce to you that we have signed off on a stipulated final order, which the director has signed. And so we've moved to dismiss and vacate the hearing and dismiss the case because we have resolved our differences.
Sounds good. So you'll file a motion to dismiss with a proposed order and an exhibit of this stipulated final order.
Yes, it
Okay.
was filed yesterday. In fact, yesterday evening. So
With those documents.
with Freya, yes.
With those documents that I just listed.
Yes, sir.
Sounds good. We're off the record in that case. We're going to call case number, let's go back to case number 2. It's far after 9 a.m. I'm going to recall Oil Conservation Division versus Blue Ruby Operating. Do we have anyone from Blue Ruby Operating with us?
Yes, sir. My name is Daniel Baker.
Very good. Can you turn on your camera, sir?
It's on. Is it showing me?
It's not, sir. You might have do you have a slider across the front of the laptop or something like that that you can slide the other way? There you go.
There we
That's
go.
it. I can see you. Perfect. Okay. Good morning, sir. Do you represent Blue Ruby Operating?
I do. Yes, sir.
Okay, good. Would you spell your name for the record, please?
Yes, sir. It's Daniel, Daniel, Baker, Baker.
Okay, very good. So, Mr. Baker, what is your capacity representing Blue Ruby?
I'm the president.
You're the president. Okay, perfect.
Yes, sir.
And have you been communicating with Mr. Hall in this office?
We have communicated a while back. Yes, sir.
Okay, sounds good. Earlier today, before I understood that you were told 9 a.m., Mr. Hall moved for the admission of some evidence, exhibits 1 through 3.
Yes, sir.
Into evidence. Now, you should have received those exhibits along with your, would it be the notice of violation, Mr. Hall, or would it have been a docketing statement?
So all of those should have been received by the operator, by Mr. Baker's the email we have. But those particular documents we seek to admit, which would be actually exhibits 1, 2, 3, and 4, are attached to our pre-hearing statement.
Okay. Mr. Baker, have you seen any of these documents?
Yes, sir.
Okay, very good. Have you seen the documents marked exhibits 1 through 4?
I believe so. Yes, sir.
You believe so? All right, sounds good. Do you object to any of those? And if so, on what grounds?
No, sir. No objection.
Okay, then I'll reaffirm that we have admitted exhibits 1 through 4. Earlier it was 1 through 3, but now it's 1 through 4 into evidence. All right. Now, Mr. Baker, I don't know what your position is regarding this case. Do you dispute any of the allegations?
No, sir. We're not disputing them. We have inactive wells currently. We're aware
Okay.
of that.
Mr. Hall, how many, since I'm not looking at the exhibits, in this case, how many, what are the allegations in this case?
Allegations are this operator operates 8 wells, all 8 of which are inactive.
Okay. And Mr. Baker, you don't dispute that all 8 are inactive?
Well, so currently 6 are, 2 are plugged. We're working on getting the C-103s filed for that.
Okay. Mr. Hall, did you know that?
I did not know. That's good news.
Okay. Do you want to, so Mr. Baker, can you be specific about which 2 wells on the inactive well list? It'll be one of the exhibits. It'll have an Excel spreadsheet of the wells.
It's the 2 Sim States wells, the Sim States 35, number 1 and number 2.
Hold on, Mr. Baker. Mr. Hall, do you see that? Okay.
Yeah, that's all those wells are going to be listed on Exhibit A to the NOV. And those would be Sims 35 state are the last 2 wells in that exhibit.
So does that mean that you will revise your, does that change your case in any way that now you are?
It actually doesn't, other than we will help facilitate the proper filing of documents and we're glad that's happened, that they've been plugged. We're happy to help facilitate in any way getting the proper documentation filed on that. It might give me, if it weren't this late date, some room to negotiate on civil penalties, but in terms of those wells being inactive on the inactive well list at the time of the filing of the NOV, that would not affect that. So we're happy that they're moving toward compliance. That's all that would change.
Okay.
Yeah.
All right. So what you're saying, Mr. Hall, is whether a well is plugged or not, if it's inactive for a certain period of time, something needs to happen. Either it needs to be plugged or put back into production or something.
Right. And that's a lot of times we do these stipulated final orders to sort of memorialize some of these acts, but here we are at hearing and they have not availed themselves of opportunity to discuss that kind of an agreement.
Okay. What is the fine in this case?
It is, I believe, I'm almost there. 3,600 is the amount requested in the
For the 8
NOV.
wells.
For the 8 wells.
Okay.
And that's broken down, just FYI, in case you decide to do a different number. That's determined at $450 a well. So if you wanted to give them credit for 2, that would be your prerogative. We're not asking for that. We're asking for the full amount.
And you said that the total fine was what?
3,600. 8 wells,
32
times
and
450.
Yeah, 3,600.
Yes, sir.
And is there anything else that you're seeking besides the $3,600 in fines?
Yes, we're seeking the civil penalty, which you just mentioned, authority to plug,
Right.
The ability to terminate, their ability to transport,
Right.
the ability to forfeit financial assurance, shut in the wells, remediate or restore the location in the event of environmental contamination, and the ability to modify, suspend, cancel, or terminate permit.
Okay. Mr. Mr. Baker, did you understand what Mr. Hall said?
Yeah, the authority to plug.
Yes.
Is Mr. Hall saying the state is wanting to plug them themselves? Is that what that is?
No, we want you to plug them, but
Okay.
but since you haven't, we seek an order allowing us to do that.
But the
And Mr.
order isn't necessarily saying you're doing it. That's just an order saying you can. So essentially our point, we have a plugging contractor lined up to do 3 additional ones. We hope to have those completed by June. We were going to take July off and then have the remaining 3 hopefully done in August is kind of our plan.
Mhm.
If that satisfies Mr. Hall and you, Mr. Examiner.
I think, so Mr. Hall, hearing what he just said,
Mhm.
that it's in the works to do the other 6. Does the order allow some time for him to complete this?
It doesn't, but I will make an internal note in the files that these shouldn't be priorities because the operator intends to plug. And, you know, our folks that look into that would then be able to say, okay, let's not do that one. But it's not a perfect system in that
Sure.
sense, since we're here at a hearing and, you know, but no, we would way rather them plug them than that fall on the state.
Mr. Baker, do you have anything else that you want Mr. Hall or myself to know about these 8 wells, 2 of which are plugged?
No, sir, I don't think so.
When were the 2 plugged?
Oh, I'd have to go pull some dates for you.
Okay, why don't I give you 5 minutes to go pull that data? I'll
Okay.
go and recess on this case. I'll call another case. You can just turn your camera off for a bit. I'll
Okay.
recall this case and find out when they were plugged.
Okay, thank you.
Thank you, sir. Okay, I'm going to call the last case on our docket. This is number 12, Oil Conservation Division versus Respondent H&M Disposal, case number 26072.
Yes, let me pull that one up, Mr. Hearing Examiner. I do know we moved for a continuance in that one.
I see that.
And I just want to pull, and now I'm starting to get stuff mixed up in my head. So let me not say anything wrong. Try this a different way. Oh, yes, I'm remembering now. If I'm not mistaken, I've been speaking to the representative of the operator and I believe they are either have or are intending to plug shortly, but let me pull that motion up. Oh, and I should also note they've already paid the civil penalty.
Based on an agreement?
I think so. Think
But you're not
I
sure.
think Mr. Harrod said, "What's the civil penalty? Where do I send it?" And so yeah, so I think that's what happened. Here it is. Now I have this continuance. Okay. Yeah, he's having some problems logging into the system, and just needs a little more time. I think he's trying to remediate the site as well as get all of his C-115s filed. And so,
But the parties are in agreement to continue this case
yes,
to June 20.
we don't have an SFO yet. I think we're trending in that direction, but yes, we are in agreement in terms of continuing the case.
And there is no one representing H&M Disposal with us today.
Not that I'm aware of,
Okay.
however, no, I just received an email from their representative at 10:12. He's having difficulty logging into the hearing. So he's trying. It's a function of computer incompetence, not disrespect for the proceedings, he says. So,
Okay, well, I'll grant the continuance.
okay.
If he's listening, I want him to know that this will be the final continuance. If there's going to be a settlement agreement, it needs to be worked out before June 25th, or else this case will go to a hearing
Great.
on that day. So we are in recess on that case, and I'm not going to sign the order for a continuance because I'm granting it verbally.
I'm sorry. Could you restate
Sure.
that?
I know that you sent a few last minute continuances along with proposed orders. I'm dealing with them verbally.
Oh,
So I'm
sure.
Granting
Okay.
them, so I won't be signing them and sending.
Fair
them
enough.
back. Okay, so let's go back to Mr. Baker. Mr. Baker, do you have that date?
I do. So the number one was April 20th. And then the number two was back in December of 25.
Okay, and when you say number one and number two, are you?
Sorry,
what
the Sims State 35 number one and Sims State 35 number two. I apologize.
Okay, now I understand. Okay, very good. So one was plugged in December of 25,
Yes, sir.
and one was just plugged a few weeks ago.
In April. Yes, sir.
All right, very good. Mr. Baker, do you have proof of that?
We've got the C 103s to file.
Okay, perfect.
We'll get them filed, and then I can provide them to Mr. Hall.
That'd be
yourself.
That'd be perfect. That'd be
Okay.
perfect, Mr. Baker. If you'll provide those to Mr. Baker, it may be helpful to you in your case. So I'll give you a deadline for that so that there's no misunderstanding. Today is the 5th of May. You provide those by the 8th of May, close of business, 5 p.m. to Mr. Hall, and it may be helpful to your case.
Okay.
Okay? Anything else, Mr. Baker?
What's the next step here? How does this go? How does this work from here?
Mr. Hall?
Well, yeah, if you stay in touch with me, we'll help you facilitate the filing of the forms. I mean, given that I guess it's the hearing examiner's determination where we go from here. Given the evidence we presented, we have these orders, but we want you to plug them, like I said. So if you're communicated with me or whoever else I might direct you to, that will be good. I don't really have authority as I sit here now to negotiate on civil penalty, but the hearing examiner can set that wherever he wants to too. And I think he said it could be helpful to your case that you do these things. So we'll work with you any way we can. I hope that answers your question. Where we go from here is hopefully you plug all these wells as soon as possible.
Well, that's our intention. I didn't know. I guess I meant more formally. Is there a final order from here?
There is. Mr.
Okay.
Baker, let me see if I can be helpful to you. What happens now is Mr. Hall drafts a proposed final order.
Okay.
I review the proposed final order. I examine the evidence and I issue a final order to the director for his signature. This will take about a month. Okay. And then I believe in the final order, it also gives you a period of time to plug those wells as well. Is that right, Mr. Hall?
Yes.
I thought so. 30 days, right?
Yes.
That's what I thought.
For it to take effect. So
So Mr. Baker, you're going to have approximately 2 months
Okay.
to submit those forms showing that you've plugged all 6. Well, I guess the first 2 of the 8, you'll provide that evidence by Friday,
Yes.
and then you'll file those correctly in the portal.
Yeah.
Then you'll file the other 6 documents showing that you have plugged the other 6 wells. And if you do that all within, let's say, about 2 months or so, then that should end the case, except for whatever fine I determine to be reasonable.
Okay.
And that's formally what you're looking at,
Okay. Thank you for that.
of course. And by the way, as you plug the wells, you said you had 3 scheduled for plugging, if I'm not mistaken, in June, you said?
We did. Yes, sir.
Yeah, I would file those as soon as they're plugged. I would file those to show the division that you are a man of your word and that we can depend on you.
Yes, sir.
All right. If there's nothing else, Mr. Hall?
Nothing else from OCD.
Very good. Thank you, Mr. Baker, for your participation. And we're off the record.
Hey, thank you. And thank you, Mr. Hall, for your help.
Bye-bye.
Thank you, Mr. Baker.
All right, we are back on the record. It is 10:26 on May 5th. It was brought to my attention that we have a number 13 case. It is the Oil Conservation versus Scorpion Oil and Gas, case number 26073. Do we have anyone from Scorpion Oil and Gas with us? Mr. Hall, do you want to enter an appearance?
Yes, Michael Hall on behalf of OCD. We're present and ready to proceed.
Thank you. Have you communicated with it? Oh, all right. Okay.
We have not known. In fact, there's been emergency orders against this operator and they were not communicative to that either.
All right. So I'll say that Scorpion Oil and Gas is a no-show. What evidence did you want to admit into the record?
We would offer exhibits 1, 2, 3, and 4 attached to our pre-hearing statement.
Your exhibits are admitted without exception. And is it my understanding that you have not heard from any representative of Scorpion Oil and Gas since you filed this NOV?
To the best of my recollection, that's correct.
Okay. So what is the allegations in this case?
The allegations in this case is they operate 46 wells, 43 of which are inactive. Also a failure to file some C-115s. And so the civil penalty is a lot larger in this case than our typical ones we've been doing lately on inactive wells. That is $73,350. And so, yeah, it's inactive. It's basically they've completely failed to do everything an operator should do, as more thoroughly set out in the NOV.
And is there anything else that makes this case distinctive?
Other than there's been emergency spills that they've OCD's reached out to them and they haven't responded to that either. And so just complete dereliction of duties. I mean, that's not that different, but the volume of wells and the emergency aspect certainly caused some more concern than typical.
Okay. All right. If there's nothing else about this case, then are you drafting an order for this case?
Yes, I will.
Okay, very good. Well, Mr. Hall, thank you. And we're off the record again.